Good afternoon. Good afternoon. Like it. I am Dean Usha Rodriguez, and it is my very great pleasure to welcome you to the University of Georgia School of Law and the 124th John A. Sibley Lecture. Here at the University of Georgia School of Law, we are committed to redefining what it means to be a great national public law school. We offer a hands-on, purpose-driven educational experience that matches excellence with access. This vision comes to life through three words, which are familiar to some of us, but we have some guests at the law school here, so I'll tell you them. They are prepare, connect, and lead. We prepare our students both inside and outside the classroom through courses, externships, and practical training. We connect them to thought leaders, including our faculty and distinguished guests, and we inspire our students to become leaders, both in the legal profession and in our communities. Now, at the law school, we are fortunate to have an endowed lecture series that is dedicated to bringing outstanding legal scholars of national prominence to campus. In 1964, the trustees of the Charles Loredens Foundation of Atlanta established the Sibley Lecture Series in tribute to the late John A. Sibley, who was a 1911 graduate of this law school. Thanks to the Loredens Foundation, this lecture series honors the leadership and public spirit of John Sibley, whose service to the School of Law and the state of Georgia spanned a period of nearly 80 years. Importantly, this forum gives our students the opportunity to connect with legal thought leaders from around the country. In the roughly 60 years since the Sibley Lecture Series was established, the School of Law has attracted more than 120 distinguished legal leaders from across the nation to speak on a variety of topics. The first lecture, given by Yale Law School's Professor Myers S. McDougall, took place on November 30th, 1964, and focused on jurisprudence for a free society. Since then, the law school has hosted many other influential speakers, including Supreme Court justices, other distinguished members of the judiciary, and legal professionals in academia and public service. Today's lecturer is no stranger to the School of Law or to the University of Georgia. Former U.S. Deputy Attorney General Larry D. Thompson has led classes at the law school on and off since 2001. In fact, he was teaching a class on corporate criminal investigations here as an adjunct when he was confirmed for the second-in-command post at the Department of Justice. He has held the law school's John A. Sibley Chair of Corporate and Business Law since 2011. Yes, that's the same John Sibley for which this very lecture is named. Professor Thompson and his wife Brenda have also been longtime supporters of both the law school and the university. They have a particularly special relationship with the Georgia Museum of Art, which houses a collection of 100 works by African American artists that were donated by the couple. To date, Professor Thompson's distinguished public and private sector career has spanned approximately 5 decades. Some highlights include prosecuting complex cases as U.S. Attorney for the Northern District of Georgia, directing internal investigations and defending individuals and businesses in special matters as a partner in a major law firm. He has also served as General Counsel and Senior Vice President of PepsiCo twice. During his tenure as Deputy Attorney General, he led the Department of Justice's National Security Coordination Council, as well as the government-wide Corporate Fraud Task Force. In 2000, Congress selected him to chair the bipartisan Judicial Review Commission on Foreign Asset Control. And in 2004, he served as a senior fellow with the Brookings Institution in Washington, D.C. Prior to his service as U.S. Deputy Attorney General, Professor Thompson was a partner at the Atlanta-based law firm of King & Spalding and was co-founder of the firm's Special Matters and Government Investigations practice. He was the U.S. Attorney for the Northern District of Georgia from 1982 to 1986, and from 1995 to 1998, he served as independent counsel for the Department of Housing and Urban Development Investigation. More recently, Professor Thompson served as the independent corporate compliance monitor and auditor for Volkswagen AG, which was a U.S. Department of Justice appointment from 2017 to 2020. And since 2015, he has served as counsel at the law firm Finch McCraney. Professor Thompson has received numerous awards for his professional achievements, including the Edmund Jennings Randolph Award for Outstanding Contributions to the Department of Justice's mission, and the Outstanding Litigator Award from the Federal Bar Association. He holds a bachelor's degree from Culver Stockton College, a master's from Michigan State University, and a law degree from the University of Michigan. Before inviting him to this podium today, I would like to give a special welcome to UGA President Jerry Moorhead, who I'm pleased to say is a graduate of our very own law school. We also have Jill Walton, UGA's Vice President for Development and Alumni Relations, in addition to former law school deans Rebecca White and David Shipley. Notably, Professor Thompson served under both of them and also under Dean Bo Rutledge, who I don't see quite here today, but I know he will be here or wants to be here soon. Notably, we are also proud to have David Odo from the Georgia Museum of Art present. The School of Art partnered with the museum to provide a limited number of copies of Professor Thompson's new book, Quiet Counsel, Looking Back on a Life of Service to the Law, to several attendees. Thank you so much, David, for your partnership. I just want to say what a joy it is and how indicative of the impact that Larry Thompson has had on our community and on the nation, that we have representatives from the School of Art present, representatives from the university, lawyers, and the law school itself. You really have touched so many different parts of Athens and UGA, and we are so, so grateful. So, please join me in welcoming former Deputy Attorney General of the United States, Larry Thompson.
Thank you, Dean, and congratulations on your appointment. And I think that the law school is well positioned for continued success under your leadership. And it's good to be here. A number of people, I'm looking out into the audience, a number of people have been very important to me who are associated with the university. And first is President Jerry Moorhead. I've known Jerry for well over 30 years. We were colleagues in the United States Attorney's Office for the Northern District of Georgia. Jerry's a friend, a dear friend, and more importantly, as a litigator, the closest you can get to a lawyer is to try a case with them. And President Moorhead and I actually tried a case. We prosecuted a case in the Northern District of Georgia before Judge Robert Hall, and we convicted the bad guy. So it's good to have you, President Moorhead. And General Counsel of the university, Mike Raber, worked with me at the law firm of King & Spalding. Mike is a terrific lawyer. We had together a really tough case involving one of the more prominent criminal defense lawyers in Atlanta, and we were able to get the matter closed without any indictment, largely because of the work of Mike. Thank you, Mike. As the dean said, the law school has been a very important part of not only of my life, but my career. I taught here on and off since 2001, and that teaching has been very important to me because my classroom preparation and my interactions with students really have made me a better lawyer, but more importantly, it has given great satisfaction to me in my career that I otherwise wouldn't have had. So this is a very important part of my life, and it's really terrific to be here. Now, my journey to teaching at the University of Georgia Law School has not been without obstacles. So when I first applied for a position to teach here as an adjunct professor, and I'd been practicing law 25 years, I think, fairly successfully. I tried cases and won cases, and I was turned down for my first teaching job. And the reason I was turned down because I hadn't written a scholarly article since I graduated from law school, notwithstanding my 25 years of practice. And eventually, I was hired to be an adjunct professor by Dean David Shipley. Thank you, David. For overruling your predecessor. And then I was hired as the John A. Sibley Professor, Chair of Corporate and Business Law, a great honor, by Dean Rebecca White. So thank both of you for my continued employment and association with the University of Georgia. This is my first book, and I must say that it would not have happened without the help and support of Dean Bo Rutledge. I don't thank you, Bo, and Kara Musiano, who did terrific legal work for me in getting this book to completion. And the book is really a paean to the power of law to make our country better, to make our country good. I strongly believe that when you look at the arc of history, that the law, properly applied, has made our country more prosperous, it's made our country more inclusive, and it's made our country more just. And that's what I've tried to do in my career. The process of getting the book published has been very interesting. I had 3 turndowns, and so you have to be strong, and it's a humbling experience to try to get a book published. But interestingly, one of the publishers said to me, in turning my book down, he said, Larry, you've had a long career, and I'm sure you have some enemies. And I said, well, I don't know if I have enemies, but I have some people I really don't like, and they don't like me. I don't know if they're enemies. I don't know if you classify it. But he said, well, in order to have a successful book in Washington, and he viewed my book as a Washington book, in order to have a successful book in Washington, you have to identify your enemies in the book and then settle the score in the book. I didn't do that. I didn't do that. But one of the things before I get into the book, a lot of people ask me is, why did you write this book? What possessed you to go through 2 years of preparing a draft? And you know, I don't know, except I don't think, and when you read this, you can make your own judgment, I don't think it was a vanity project. I really don't think it was a vanity project. I've had these 3 buckets in my career, my legal career. I've been in public service, I've been in private practice, I've been a chief legal counsel of a large public company, and I've had a lot of different important legal policy issues and experiences that I thought maybe could help people, young lawyers, public policy people, in helping to make this country better. You know, one of my favorite quotes is from my second favorite former Attorney General. Griffin Bell is my first, but Robert Jackson is my second favorite Attorney General, and he had a quote that I think is just as important today as it was when he made the quote, and that is, you know, it's not the role of government to keep we citizens from falling into error. It's the role of we citizens to keep the government from falling into error. And I think that was sort of behind one of the reasons why I wrote the book. But my wife and I go to Chautauqua, New York, which is an enclave in western New York every year, and there's all kinds of things done up there. My son calls it the NPR crowd, the camp for the NPR crowd. But I had a friend come by who is an Episcopal priest, and we were talking about my book. And she says, you know, Larry, I think the reason you wrote this book is because it's a form of closure for you. And as I look back, and to be honest and to be candid, I think writing the book has been a form of sort of professional closure to you. So, Dean, I don't want to embarrass my colleagues in the law school, so I do have prepared remarks with footnotes, but I'm not going to use them today. I'm going to just talk from my handwritten notes, and hopefully that'll be sufficing, and you can do whatever you want with my prepared remarks. So the book covers, as I said, some of the policy things I've been involved in. I talk about national security. I'm going to elaborate on that in a minute. You know, I talk about law enforcement, white-collar law enforcement, which is something I've been deeply involved in throughout my career. I talk about diversity, and not only diversity in the legal profession, but diversity in the business world. I talk about violent crime, and I talk about corporate culture, which is something I've really been involved with deeply too, in addition to law enforcement. And I talk about all of those things in the book, and I will not be able to cover all of them this afternoon, but I would like to begin with my service as Deputy Attorney General of the United States under George Bush. I was actually teaching here at the time I got the call from the Bush people about perhaps joining the Justice Department. And I said, that'll be interesting. And they said, well, we have you in mind for several roles, including the Attorney General. Well, I didn't get to be Attorney General. President Bush selected John Ashcroft, who continues to be a dear friend, as the Attorney General of the United States. And I was asked by someone in the administration to be the Deputy Attorney General. Well, I was 55 years old then, and taking a job in government would have really been a tough pay cut for me. And I said, I don't want to be number two. And I thought it was over. Well, New Year's Day, after the election, I get a call. Brenda answered the phone, and it was President-elect and Governor Bush on the phone. And he asked me to be a part of his team as Deputy Attorney General. And he said, I know you need to talk it over with your wife. Give me a call back tomorrow morning. And of course, you can't turn down an offer, if you will, from a president-elect to serve your country. And I accepted the position. And I was sworn in as the Deputy Attorney General of the United States in May of 2001. And it looked to be sort of a routine experience. I'd practiced law for over 25 years at that time, but it wasn't routine at all. I started going to meetings of the National Security Council. I was on the Deputies Committee of the National Security Council, and I was exposed to all kinds of things that I wasn't exposed to as a lawyer practicing law in Atlanta, Georgia. And one of the things I was exposed to was what we call noise in the system, what intelligence officials call noise in the system. And that noise was information about terrorists, radical Islamic terrorists who wanted to kill Americans and commit terrorist acts on Americans. And we were pretty certain, we being members of the National Security Council, we were pretty certain that American interest and American people would be attacked by these terrorists. No one thought that we were going to be attacked on the homeland, but we were certain we were going to be attacked somewhere around the world. Now, at this time, I had two very good national security professionals working with me. One was a gentleman by the name of David Criss, who had worked under Eric Holder, who was the Deputy Attorney General in the Clinton administration, and I kept David and asked David to stay with me when I became Deputy Attorney General. And the other person was Mike Chertoff, who went on to become the Secretary of Homeland Security, really a brilliant fellow. And Mike was the Assistant Attorney General of the Criminal Division. They reported to me, and they presented me with a startling fact, which was our law enforcement agents, especially in the FBI, and our intelligence agents, especially in the FBI, they were not talking to each other. They were not exchanging information with each other. And the reason they were not exchanging information with each other was not some kind of professional jealousy, but there had been established what we call a wall between law enforcement and intelligence to keep, to protect American citizens from having their civil liberties eroded by improperly using intelligence information for law enforcement purposes. So, for example, one of the greatest examples of misuse of intelligence information was the wiretaps that the FBI improperly undertook of Dr. Martin Luther King. Those wiretaps were not approved by any federal magistrate judge. The way the FBI justified using wiretaps for Dr. King was to establish from an intelligence standpoint that he was a foreign agent. And they used those to wiretap his telephone conversations, his conversations in hotels and motels. It was horrible, tragic. So there was a reason for this wall, but it was now not working. We were under threats from terrorists, international terrorists, and our agents were not talking to each other. So it's important to understand this date. In August of 2001, I talked to John Ashcroft, my boss, and told him what was happening. And I explained to John what we were planning to do. And he said, fine. And that is, I issued a memo to the FBI. I didn't have authority or jurisdiction over other intelligence officials like the CIA and the intelligence officials in the military operations, but I did have authority over the FBI. So I issued a memo in August of 2001 directing the law enforcement agents of the FBI and the intelligence agents of the FBI to share information with each other if there was any evidence that a law would be violated. And they would share information with my lawyers in the criminal division of the Department of Justice if there was some indication in the intelligence information that federal laws would be violated. That was a quite controversial memo. Lots of people in the civil liberties community criticized it. I got a call from the chief judge of the FISA court sort of asking me, why am I doing this? And we tried to explain what happened and the basis for doing this, authoring this memo. But we issued it August of 2001. Well, guess what? Didn't work, did it? 9/11, we were hit by evil people. We were hit by terrorists. Over 3,000 Americans perished, were murdered. And that was a tough event. And it was really tough on me personally. I felt like I had failed. I felt like my job as the Deputy Attorney General of the United States was to protect citizens and to prevent something like this from happening. And so I wrote about this in the book, and it's the first time I really had put my thoughts and feelings to paper about what had happened. And I have actually talked about this in book events since my book was published, and I've been surprised by the reception I've gotten from what happened to me, because I became ill. My internist in Washington, D.C., who was a very good physician, recognized what was happening to me, and he recommended that I see a therapist, because I really was in the midst of severe depression. And my therapist, she's living now. Unfortunately, she has dementia, but she was terrific, and she helped me through this process. I was very, very ill. But when I talk about it now, because I just kept this, I don't want to say secret, but I didn't talk about it to anybody until I decided to write the book. But I'm really encouraged. It's been kind of cathartic for me to talk about something like this. But people come up to me after these book talks, and they'll say to me, "I'm glad you talked about this. I've gone through something similar," or my spouse has gone through something similar, or my child has gone through this. And so it's just, I think, important for us and to understand that we all can get sick. We all can get sick physically, and we can all get sick mentally, and there's no difference between the two. You have to treat them and deal with them. And the other thought about this is that I am not the only government official I know who's had these kinds of things. When you're in the government, you have to make a lot of split-second decisions. They carry lots of consequences, good or bad. And I have a great deal of respect for the men and women who serve our country in high-level capacities and who are exposed to having to deal with these kind of literally life and death situations all the time. So I have a great deal of respect for what these people do. And if I can now go on to another aspect of national security, which gets into my great concern about rule of law, and I talk about this in the book, and that's what I call the ticking bomb scenario, ticking time bomb scenario. And you think about what happened to us recently in our country, in New Orleans and in Las Vegas. These kinds of things we're still exposed to these kinds of things. Now, in the book, I posit a hypothetical. And the hypothetical, I'm going to summarize it. The hypothetical is, you're a government official, it's a Sunday, and in church you get information that there's a bomb underneath FedEx Stadium in Washington, D.C., where the professional football team plays. And the bomb is set to go off sometime during the game. And you've got to find out whether this is true or not. Do you cancel the game? NFL doesn't really want to do that. What do? You also find out through intelligence sources that there are two men who know something about this. One of them is in a CIA prison in Afghanistan, and you can get to that person. It's important in situations like this where you have the ticking time bomb that you really need to interrogate people. That's a very intrusive law enforcement technique, but you really need to get to interrogation. It's very intrusive. And the other person is in Alexandria, Virginia. He is in the country legally. He's a foreign national in the country legally. And what do you do with that person? You do not have enough to get an arrest warrant. You cannot use intelligence information to get an arrest warrant. Even if you could, you have to read him his Miranda rights. He has a right to remain silent. You can get him a defense lawyer, a public defender, but you don't have time to do all that. You can authorize the FBI to take him off the streets, take him to a Holiday Inn, and no rough stuff, but to interrogate him. But if you do that, you're subject to false arrest claims. you're subject to being sued and having to maybe satisfy a judgment against you out of your personal assets, not the government assets. You're between a rock and a hard place. And I don't want to give the government in these kinds of terrible situations a blank check to do anything it wants to. I don't think that's appropriate. I actually think something like that's un-American. And I've proposed a national security court. I proposed the national security court when I left government in 2004, and nothing has happened. And we are going to get hit, or we are going to face something like that. I don't know when, but I just know it's going to happen. And before the government reacts in a horrible way, trying to prevent this, I think we need to have a national security court, which is composed of federal judges. It will have counsel that have been cleared, and it's not going to have to be. It's not going to have to meet regularly. It'll only have to meet in a rare situation of a ticking time bomb scenario, and it only applies to foreign nationals. It doesn't apply to citizens. There's no way around that. I don't want to take the rights of citizens away. But I think we need this. I think we desperately need it. Government officials are put in a tough situation. I had to make a tough decision involving a gentleman who was a dual Canadian-Syrian citizen. He was a member, and this is what I can talk about. This is in the court case out of the Second Circuit. He was a member of Al-Qaeda, and I decided to send him. He was transiting through the United States on his way to Montreal, and I decided to send him to Syria, because he had a dual citizenship. He claims he was tortured in Syria. He was eventually released. The Canadian government paid him $8 to $9 million Canadian as a form of reparation. He sued me. I had left government then. I was at PepsiCo. He sued me individually. The government agreed to represent me in court in this matter, but what happened after I was sued, I get calls from FBI agents wanting to interview me. I get calls from the Inspector General of Homeland Security wanting to interview me. I get calls from investigators of congressional committees wanting to interview me. And one congressman, John Conyers from Michigan, wanted to appoint a special counsel to investigate me, because if I had sent him to Syria knowing that he would be tortured, that's a criminal offense. And so John Conyers wanted to investigate me and possibly put me in jail. So what do you do? I'm not going, my mother didn't raise a fool. And so I'm not going to sit down with an FBI agent without my own lawyer present. So I retained the law firm of Baker Botts, and they agreed to represent me during these interviews with the IG, Inspector General, with the FBI, with congressional investigators, and they had to charge me. And they gave me what I call the friend and family rate. It was very low. But at the end of the day, as a private citizen, having served my country, I incurred legal fees of $27,000. That's not right. And I'm not the only former executive that has to put up with that kind of thing. But I really think these are the reasons why we need a national security court. I hope my book sparks an interest in something like this, and an interest in preserving our rule of law in the national security area. We cannot give the government a blank check, even something as important as national security. So I talk about that in the book. One other matter I'd like to cover from my time as Deputy Attorney General that I talk about in the book is white-collar law enforcement. President Bush, following, you remember Enron and the collapse of Enron and the corporate fraud allegations that surrounded Enron and the other corporations, President Bush asked me to be the head of the government-wide corporate fraud task force. And so we set out in the task force to really be aggressive with respect to what we were discovering, which was a lot of corporate fraud in the financial aspects of corporations. And we were very aggressive in our pursuit of these matters. Some people in the president's economic advisory team thought what we were doing was too aggressive. They thought we were demonizing business. We weren't. We were approaching crime, as we call it, in the suites, the same as we approach crime in the streets, in an aggressive way. I get a call one morning from Alberto Gonzalez, who was White House counsel, and said, you know, Larry, the president wants to see you and Bob Mueller, who was the director of the FBI. We want to talk about the corporate fraud task force. And he wants to see you tomorrow. Wow. So I called Bob and told him, and then we said, what are we going to do? You know, there's a legitimate law enforcement reason for using task forces, and there's a legitimate law enforcement reason to approach white-collar crime in an aggressive manner, as we were doing. Bob and I decided, you know, we don't have a lot of time with the president, and we're not going to get into theoretical law enforcement techniques. So what we decided to do with President Bush was to tell him about some of the matters that were coming up in our grand jury investigations, where one CEO deliberately lied to the investing public during a quarterly earnings call, where another CFO deliberately lied to outside auditors during a meeting between the finance department of that company and the outside auditing firm. And we gave the president examples of that, and I'll never forget this. President Bush then turned to one of his economic advisors and said, we can't let people get away with this, can we? Then he turned back to Bob and me, and he called me LT sometimes, and he said, LT, Bobby, good job, keep up the good work. And that was really reassuring, because the president clearly understood the moral hazard associated with not enforcing business crime and yet enforcing violent crime, street crime, drug dealing, drug organizations. And it's a moral hazard if we ignore, I think, business crime. So President Bush clearly understood that. It led to an interesting academic debate that I had at the University of Michigan Business School, where there were some people sort of basically taking the stance that we shouldn't have aggressive law enforcement in the white-collar business crime arena, and we should instead have more regulation. I think regulation only catches the last bad guy, and it can be harmful to people who want to obey the law, and I think enforcement is clearly a better way to go in terms of these kinds of crimes. But you need something. You need regulation and or enforcement. You can't do away with either. So that may be a political comment, but how am I doing on time? I'm good. So let me, and I'm going to get into a substantive area, but I want to talk about another interesting thing that happened to me. Most of the book is about not things that happened to me, but about policy issues. But I would like to, we have what I call a what if moment in my career, and I'd like to share it with you if you don't mind. I had, again, left PepsiCo, and I get a call. Not PepsiCo. I'd left government, and I'm at PepsiCo, and I get a call from Josh Bolten. You may remember Josh Bolten was the chief of staff to President Bush. And this was following the retirement of Sandra Day O'Connor from the Supreme Court. And when she retired, President Bush recommended his friend and a very good lawyer, Harriet Miers, to serve on the Supreme Court. And there was an uproar about Harriet Miers. Many people didn't think she was conservative enough, or didn't have the scholarship that was needed for a Supreme Court position. And she eventually withdrew her name from consideration. Now, normally the Deputy Attorney General doesn't meet with the President as frequently as I did. I met with him almost every day that we both were in the office. You normally don't meet as frequently, but we became close. He trusted my counsel and advice. I liked him. And Josh said to me, "You may get a call from the President about the Supreme Court position. Are you willing to take it?" And again, I talked to my wife, and we felt that obviously you can't turn down this opportunity as a lawyer. And I told Josh that I would be willing to take the call. Guess what? The call never came. Now, why didn't it come? I didn't know. I never knew. And then 5 or 6 years later, I was reading a book by Jan Crawford Greenberg on the Supreme Court. And she writes in the book about what happened. And that is a gentleman, and I think he's a friend, or was a friend, Alex Azar, who was the Secretary of Health and Human Services during the first Trump term, had heard that I might be considered for this position. And I think in any event, I was a very long shot, but I might be considered. And they were concerned. They knew about the relationship that President Bush had with me. And they were concerned because they said, according to Jan Greenberg, I was a good guy. I'd represented Justice Thomas before in his confirmation proceedings before the United States Senate many years ago. They thought I was a good guy, but they did not think I was grounded philosophically and legally in a way that satisfied them. I had never spoken out about abortion or any reproductive rights issues. I'd never spoken out about Second Amendment issues. And there was a reason for that. I was practicing law. I don't think my clients would appreciate hiring me and having me go out and speak about all those kinds of controversial issues. But in any event, they actually thought I would tilt left or to the position of Anthony Kennedy. And so it was really interesting to read several years after all this happened, why I never got the call. Now, does anyone here think they know who did get the call? This is the what if kind of thing. Well, the person who got the call was the Honorable Samuel Alito. So I call that a what if moment. So I have time to.
You want to do some questions?
Okay, you want me to do that? let me just, because I've taught here, and, really one of the highlights of my career, and I taught a class called Corporate Responsibility, and the next thing I write about, if the good Lord gives me time to do it, it will be this area of corporate responsibility. I took the PepsiCo General Counsel job, and I write about that, terrific experience in the book. And it turned out not to just be a routine, dull corporate job. It was a righteous cause. And I dealt with issues, you all know about Milton Friedman and the philosophy that a business corporation, the only responsibility that a business corporation has is to make money for its shareholders, profit maximization. Well, lots of people on Wall Street adhere to this, and they've actually, even though Friedman didn't talk about the term, they actually They actually talk about it in terms of short-term profit maximization. And I dealt with these issues as the chief legal counsel of PepsiCo my entire 10 years there. And we had to deal with them. And I actually write about in the book that we are now experiencing what we might call political populism. And I think one of the reasons that we are experiencing political populism is that corporations, most American corporations, the professional investing community, they have to deal with Wall Street that adheres to this philosophy. But we lawyers know that there's another philosophy that's perfectly legal. There's a business judgment rules. The corporations can take the long-term view. Corporations can run their business not just supporting shareholders, but supporting stakeholders like communities, employees, the consumers of their products. That takes time, that takes away money in the short term, not necessarily in the long term, because I think corporations who run their business for the benefit of stakeholders as well as shareholders are more sustainable in the long term. But I do think that the rise of political populism is because many corporations have forgotten that they need to run the business for the stakeholders, employees, communities, even consumers. And so I have a chapter in the book dealing with that. One of the things you lawyers who are in the room, I assigned this law review article to my class in corporate responsibility. And it's a 1932 Harvard law review article that I think is really relevant today because it's by a fellow Professor Merrick Dodd. And Professor Dodd said at the time in 1932, corporations, if you run your business and ignore the stakeholders, and he was especially talking about employees, but could be other stakeholders, public opinion will change. Public opinion will change, and you will be forced to deal with either more laws, or regulations, or leaders who are antagonistic to your business. And think about many American corporations forgot an important stakeholder in their business, the employees, and the corporations were shipping jobs outside the United States, especially in the manufacturing sector, were shipping jobs outside the United States to other countries, lower cost, short-term profit maximization, and guess what? Public opinion changed with respect to that activity, and we now have political leadership who is advocating all kinds of ways to bring these same jobs back to the United States, but at what cost to the businesses. So that's something that I'm very, very much interested in, as the dean knows, and that will be. And by the way, Dean, the dean that rejected me, Dean Shipley, the dean that rejected me, I did finally write a scholarly publication. It was published while I was a faculty member here at the University of Georgia, and I'm proud of that too. So, we have time for questions?
Absolutely.
Okay. Any questions? Yes, sir.
So in 2003, you wrote a memorandum, which is still followed by the DOJ today, which provided guidelines for federal prosecution of businesses and their organizational behavior. How do you think that, in assessment of it, how do you think it has impacted even organizations today?
Yes, I think that's a good question, because as you know, that memorandum was criticized by a lot of people, and including one of my colleagues here at the University of Georgia Law School, but that's okay. My son's, the Wall Street Journal has written a number of editorials against that memorandum, although it was superseded over 20 years ago by the Philip memorandum. But the Wall Street Journal, when they write about white-collar prosecution. And the editorial page of the Wall Street Journal basically has never seen a white-collar prosecution that they agree with. But when they write about it, they don't refer to Mark Phillips' memorandum. They refer to the odious Thompson memorandum and its progeny. So I've been long gone from the Department of Justice, and they will not leave me alone. My sons say, "Dad, don't worry about it. It's going to be in your obituary." And it probably will, that I was the architect of destroying the attorney-client privilege in violation of the Sixth Amendment of the United States Constitution. But that's okay. I'm proud of the work we did. Thank you. And by the way, it is, the essence of that memorandum is still followed by the U.S. Department of Justice. Dean?
So, Larry, you spent such a lot of time in D.C., and you also spent a lot of time in academia, and really close ties to both. I wonder what your thoughts are on what's going on in terms of higher education, the government now, and what your feelings are as to why that relationship has changed, and what, if anything, we can do about it.
Well,
Can you repeat the question, Larry?
yes.
So,
Yes, sir. The question is, what do I think about how academia is relating to some of the issues today, and some of the things that some universities have done in response to criticism. I think there were some serious mistakes made by the leaders of some universities. I've talked to you today, this afternoon, about terrorism and how, as a civilized society, we can never tolerate terrorism, the killing of innocent people. That's a core value. And when I saw what was happening, for example, I'm going to call this university out by name, Columbia University, and the leadership of that university was afraid to take a stand on terrorism, notwithstanding all the issues associated with the Palestinian-Israeli relationship. I was disappointed. I know that at the University of Georgia, you took a tough stand. You certainly did not stamp out the right of free speech and so forth. You set proper legal regulatory controls on free speech. But you also took a stand condemning terrorism. This is against our Judeo-Christian principles. So on that part, I really was disappointed. However, I don't think that the government should now step in and tell universities how to regulate speech and the kinds of things that have gone on in Columbia. I don't know the details of Columbia's accommodation with the new administration, but what I've heard, I'm very much concerned about. And I think academic freedom is important. I'm buoyed by the fact that we have at our law school here, we have a record number of applicants, and so we're going to get a lot of bright people who are brighter than I am in to help make our country better in the future. But I'm concerned about the government intruding too much into things that are constitutionally, that we constitutionally have a right to do, and or we're constitutionally protected. So, for example, a basic constitutional protection is that the government cannot attempt to do something to harm me in the civil capacity without due process. And this is being ignored in many instances today. So, I hope that answers your question. Yeah. Yes, sir.
You spoke about the idea of an intelligence court. Can I ask you to sketch out a little bit of your vision of what an intelligence court would look like? How it might be different than FISA and its authority?
A national security court.
Yes.
So, like FISA, it would only apply to foreign nationals. And you might ask, what did we do about domestic terrorists? I just don't think you can take away somebody's rights that are embedded in the Constitution. But domestic terrorists present less issues associated with infiltration. We're pretty good at infiltrating some of those terrorist rings. And foreign terrorists present more of a problem. It would be similar to FISA and would only apply to sort of ticking time bomb scenarios where you have to make a quick decision for national security purposes. Intrusive things like interrogation would be one. A quick decision on rendition would be another. And you would have federal judges who are properly cleared. But the one distinction I would have that would make it different than FISA, because FISA is not an adversary process, would be you would have cleared defense lawyers, a panel of cleared defense lawyers, because to do something like interrogation and rendition, I think the target should be represented. And I don't know all of the security issues that we face today that would prompt the National Security Court to come into being. But I do know this, I don't want to give the government a blank check for these kinds of things that they will have to do. We went through some of this in the Bush administration. We essentially lost every case in the Supreme Court. And so I think it's important, if someone is here who is a foreign national and is here legally, there are important implications to, due process in handling their situation pursuant to the rule of law. David on the front row, and then the David.
All right. And thank you so much for this talk. It's great to get some insight into your incredible career and thinking about things. And I was wondering, I know there's a section in your book where you talk about your apprentice collecting and supporting your art. And I loved how you connected your insights you gained from art into your legal practice. I don't know if you can say a little bit more about that.
Yeah, I really believe this, David. I think, did you hear the question? Let me repeat. The question is, how has the passion that my wife and I have for art and collecting art in particular, how has that impacted me as a lawyer? And there is, I think, a connection there for me, because I think art has humanized me. It has given me an opportunity to meet people of all different stripes, all different backgrounds. It's given me an opportunity to understand people greatly in a greater degree. And I think all good lawyers really understand people. And my mentor as a lawyer was Griffin Bell. And I write in the book that he is the wisest lawyer I've ever known. But he could talk to the parking lot attendant, the flight attendant, or the university professor who was the head of the physics department with equal ease. And he was a terrific lawyer, and he always knew how to get to the bottom of a problem, which he said was, we lawyers, it's not our job to vanquish the opponents. Our job is to solve the client's legal problem. And I think I understood that degree of common sense better through the art world and meeting artists and collectors, museum directors like yourself. And it's made me not only a better lawyer, but a better person. David, yes.
You're mentioning Griffin Bell. Made me think whether it was you told me this story or maybe it was actually Griffin Bell. But what did he tell Jimmy Carter when he became Carter's AG with regard to the role of the Attorney General and the advice that the Attorney General gives to the President? Isn't there some story about, I'm going to tell you no at times?
Yeah, I don't remember a direct quote like that, but I do know that he sort of explained the role of the president as it related to the Department of Justice. And his view was the president can set the policies. He works for the president as it relates to the policies of law enforcement for our country. But the president should stay away from interfering with the professional investigation and prosecution of crimes, and should not interfere, and no one should interfere with these investigations and apply undue pressure or political pressure. If you'll let me talk to that, those have been really bedrock principles in the Department of Justice all during my adult professional life. And these norms, and that's what they are, they're not codified in any rule or regulation, or they're certainly not law. These norms have been very important. And you know, I always felt like, in terms of investigation or prosecution, if an assistant U.S. attorney came to me when I was a U.S. attorney and just said, from a professional standpoint, Larry, you know, I think we're doing something wrong, I don't want to work on this. You know, if it was a professional conduct issue, as a lawyer, I would honor that. And so these norms that Judge Bell and every attorney general, including Bill Barr in the first Trump administration, every other attorney general have recognized these norms are not being recognized. And they have been categorically rejected by the current attorney general. And so, you know, you just look at what happened in the Eric Adams case out of the Southern District of New York. And that's concerning, David. Okay, Dean?
I can't resist one question. So, because we have all these law students here, how did law school prepare you for that ticking time bomb, or what advice do you have for a young law student who's ambitious in either government public service, or in private practice, or in-house?
Well, you know, law school really prepared me for a number of aspects of my professional career. And I write about Professor Joe Viney at the University of Michigan Law School, who really inspired me to be interested in corporate law, but the law enforcement aspects of corporate law. I think professors, whether undergraduate or law, have been a very important part of my life. And I think there's no doubt in my mind that the University of Georgia Law School is going to put a lot of emphasis on the rule of law. You know, the rule of law is so important in our country. And I think take your job as a lawyer. You know, we are licensed by the state. You know, you just don't get a law degree and then go out and make a lot of money. We are licensed by the state of Georgia, and we have a code of professional responsibility. Take your professional obligations seriously. You know, when I was teaching here, Dean, I would jokingly tell my students that the profession of law is a calling. And if you simply wanted to get a degree from the University of Georgia and make all the money in the world, you need to go across the street to the Terry Business School.
Given your extensive experience in both public service and corporate law, how do you view the evolution of corporate responsibility over time?
Yeah, so in my class, I addressed that question, because sometimes corporate responsibility is equated with corporate social responsibility, and people think they're the same. And there is quite a bit of difference. Corporate social responsibility is what business organizations do after they've made their money. And then they donate to philanthropic causes and that kind of thing. corporate responsibility is how a corporation goes about making its money and how it can make as much money as it can for its shareholders, but assure that the business is sustainable for long-term growth. And that's the way most people invest in companies, for long-term sustainable growth. Big difference between corporate responsibility and corporate social responsibility. And corporate responsibility is not philanthropy. Corporate social responsibility is philanthropy. That's the difference.
You mentioned earlier that as those screen representing clients, you couldn't necessarily put your personal opinions forward in the public. How do you balance being an attorney and representing the United States with also being a part of the people having your own political opinions and being able to exercise those as a private individual?
You know, that's a good question. Well, I have professional duties. I'm licensed to practice law in Georgia, so I have professional duties as a lawyer licensed to practice law in Georgia. And so that's got to be number one. Then you have a duty to your client, and you have to exercise your responsibilities zealously in a way that you think can benefit the client. And you have to put those two together. But one of the responsibilities I have as a lawyer in the state of Georgia is to respect the courts and to respect the process. I have never criticized a judge publicly in Georgia. There's one judge in particular, a federal judge, who actually was lost his robe, if you will, and he gave me a terrible trial, but I never said anything publicly about him. I'm dismayed now what is coming out of the Department of Justice in terms of criticizing judges. By the way, an elected political official who's not a lawyer has a right to criticize the courts. They can criticize the judges until the cows come home. But we lawyers shouldn't do that. Is that it? Thank you.
Professor Thompson, thank you so much for your wonderful presentation and lively question and answer session. You've been a great colleague and friend to me personally, to the law school, and to the university. I invite all of you to join us downstairs for some refreshments and further conversation. But one more round of applause to thank